In Unit 2 of my Communications Law class, we have discussed the difference between obscene and indecency. Obscenity, which is not protected under the First Amendment freedom of speech, is defined as highly subjective material that display or describe sexual activity in a vulgar manner or depicts sexual organs in a vulgar manner with no artistic or literary or scientific purpose. It has no value. Indecency, which is protected under the First Amendment freedom of speech, is defined as the portrayal of sexual or excretory organs or activities. And that is the definition according to the FCC. To test whether content is obscene, there's the Miller test, which was created in 1973 following the Miller versus California court case. And that case was, Miller conducted a mass mailing campaign to advertise adult books. In the books consisted pictures and drawings of very explicit men and women grouped together engaging in sexual activities. So the Miller test is how you define obscene material, and it's 3 parts. The first part is the average person applying contemporary community standards finds the material appealing to prurient interest. The second is that the content depicts or describes offensive sexual conduct, and that is sexual conduct that's specific to state laws. So every state's laws may be different. The third is that the work lacks serious value. So that's what I mentioned earlier, that it has no artistic value or literary value or scientific value. Furthermore, we looked into obscene and indecent material as it affects minors. So we talked about child pornography, which is images of children engaging in sexual explicit conduct. So a minor is under the age of 18, and any of that is considered child pornography, which is illegal under federal law. So we have the New York versus Ferber court case of 1982, where Paul Ferber, who was the owner of a Manhattan bookstore, unknowingly sold 2 films to an undercover cop. The films depicted young boys masturbating, and Paul Ferber was indicted on promoting obscene sexual performance and going against the New York statute. And that is the state law. And that the New York State statute was that any sexual performance by a child, so a minor, sexual conduct includes sexual intercourse, masturbation, abuse, or lewd showing of genitals of a minor. And Ferber was indicted on that and of child pornography charges. So there were many other cases that went to Supreme Court because it was hard to define specifically the difference between obscene and indecent material. And it still isn't exactly concrete. That's why we have the Miller test to try to at least know what obscene material would be. But it's still really not clear cut. It's still very close.